Hello, hello, hello. Welcome, welcome, welcome. How are we doing on this fine Saturday? Well, I hope everybody has had a wonderful day. Well, by the time this gets out, it will be Sunday because it is a late Saturday. I originally had this planned to do very early in the day, but things happened and things took off and whatnot. And, hey, here we are. So, if you are new here, welcome, welcome. This is Rush to Judgment with Jessica, and I'm Jessica. Good to see you. What's going on? What's happening? If you're returning, welcome back, welcome back. So, again, if you are new here, we are working on the Nicole Nachtman trial. She is being charged with 2 counts of first-degree murder in the deaths of her mom and stepfather. She is The murders happened back in 2015, and this trial happened back in 2019. And there's no real rhyme or reason why I picked this trial, other than the fact that I like the judge. I've seen the judge in a couple different trials recently within the last year, and I enjoy him. So I found another trial that he had done, and I figured, okay, I'll watch it. So, and it just so happens that it throws in a mental health twist as well. So that was a twofer. Again, I also want to point out that I am not an expert in any of this, nor do I specialize in anything. This is not for real educational purposes. Really, if you learn something, that's cool. If you learn something that you didn't know before, and I helped you with that, that's cool. But really, this is just for my entertainment, your entertainment, spark up some conversation. Let me know what you think in the comments below. And of course, like and subscribe to the channel and check out some other things. I've got some true crime commentary. I've got a couple other trials that I did as well. And yeah, so go ahead and do all of that. And so let's get back into this and see where we're headed. We're in the defense's case in chief to part of the trial. The state rested, so now we're in the case, the defense's case. I don't even really feel like they've picked what they're doing yet, and the defense is bitchy. They're both real bitchy ladies. One more than the other. I'll let you guess which one. She's real bitchy. And I don't much care for her. I don't like the way she talks to the judge. I don't like the way she handles her witnesses, or any witnesses for that matter. She has a real crude bedside manner, if you will. So, yeah. But I guess, everybody has their own way of doing things, I guess. And that's hers. All right, so let's get going. And I guess they have some preliminary matters to discuss first, and then we get to the witness. we're still on day 5. And then after that, after this witness, I guess we get into some doctors' testimonies, and hopefully that gets a little spicy and gets a little bit more interesting on the, because I would really like to see, what her mental state is and what the experts say instead of what these family members say, because they're really kind of, you see which family members that they have up on the stand, and you see, some of them are very sympathetic with Nicole and some of them not so much. But I mean, I don't know. Just we'll watch and see what happens. Okay, let's go.
And I know the only reason I want to bring it up is I know the time constraints the court has. My intention was to hopefully get a ruling today on whether you believe you established self-defense after Eric Lear, because there's going to be a colloquy and a decision by Ms. Nachtman as to whether she has to testify.
Right.
It's a huge decision based on what we all now know to be her background and her history. This is not a decision that she is going to be prepared to make at 8 o'clock tomorrow morning or even 9 o'clock tomorrow morning. So I was hoping to have a rule. I believe by the end of my direct, our case will have been established prior to any experts. And I'd like to make argument on the self-defense issue, but I understand that the court has time constraints.
So would you like to do this? Would you like to do the direct and then I send the jury home? We'll do the cross tomorrow, and then that'll give us some time, because you're not relying on anything from the cross. Is that all right with the state?
Judge, I don't necessarily have a problem with that. The only thing I can tell the court is, if you've noticed, my crosses have been relatively brief. I'm very familiar with what Eric's going to say. I don't know how long. I don't anticipate I'm going to have a lengthy cross.
Right.
I could, and I don't have a problem.
Yours are much shorter than Mr. Terry's.
And I don't have
No
a problem,
offense, Mr. Terry.
and I don't have a problem if we just want to see where we are.
Right, let's see where we're at. Yeah, let's see how long they're direct, but I hear you.
Thank you.
All right. Ms. Nachtman is present. Let's bring them in. Jury's present and seated. Everyone else may be seated at the time. Ladies and gentlemen, jury, welcome back. Did anyone have any contact or exposure to the case, discuss the case, or do any research related to the case during the last short break? By show of hands. Let the record reflect no hands. Thank you. We are going to proceed. I'll ask the defense to call your witness.
The defense calls Eric Lear.
Eric Lear. Raise your right hand, please. Thank you. Do you swear affirm any testimony you give in this proceeding will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you'll follow the bailiff around to the ramp that leads up to the witness chair. Please watch your step. When you get to the chair, go ahead and have a seat. Make yourself comfortable. That microphone does adjust. Perfect. You may proceed.
Tell us who you are.
My name is Eric Lear, L-E-H-R.
And how are you related to Nicole Nachtman?
She's my niece.
Tell us briefly about the siblings and how you are her uncle. Who's the oldest? Who's the youngest?
I'm the youngest of 6. My sister was the next one up, 5 years apart from me. And then it's Peter, George, and then Albert and Louis. I screwed that up. It's Louis, then Albert.
And what about your mother? Is she still alive?
Yes,
How old is your mother?
88,
What about your father? What year did he pass?
2001.
So you and Miriam are back to back, and she was 5 years older than you growing up.
Correct.
Now, as far as nieces and nephews and kind of the family cohesiveness, tell me a little bit about the relationships that you have with your nieces and nephews.
Pretty much all my nephews and nieces grew up in Tampa. My mom raising them because most of the ones that have children were pretty much in the military. So they would pretty much be there sometimes for the whole year, sometimes for the summer, but it was never an empty house.
Now, did you at times also live with your mother even into adulthood?
Yes.
And tell the jury about that as far as time periods of when you lived with your mom and kind of what you did to help your mom.
Well, basically, my mom never run her drive, so I've been the youngest. I always stayed close to home. So I had a room there, but I wasn't there like 24/7. But a good majority of the time, she depended on me to take the kids somewhere or transport her to a doctor's appointment. So I've been very close by, but there's times that I do stay there.
And you were one of the siblings who did not join the military.
Yes, I did.
Oh, you did. When did you get out of the military?
1983.
But as far as the constant, I guess what I meant to say, the deployments that occurred throughout your siblings' careers, that did not apply to you. You were in Tampa after 1983.
Yes, from 1983 on.
And then Nicole was born in 1994. Is that your recollection?
Yes.
Now, your brother Peter was also in the military. Is that correct?
Yes.
And do you know why he was discharged from the military?
As far as I understood, it was some kind of, depression type of discharge.
So some type of mental illness where it was an honorable discharge.
Yes, it was honorable.
Now, as far as your nephew, Nicole's brothers, Kevin and Joey, what was your relationship like with them during their childhood?
They spent a lot of time at my mom's house, and I would take them pretty much everywhere. So they kind of grew up with me, kind of being like a father figure.
And what year did Kevin pass away?
I'm
2003 sound right?
Yeah, about Christmas time, close to that.
Now, Joey and Nicole was the youngest of all of Miriam's kids.
Correct.
And there's about a 12-year age difference between Nicole and Joey.
Yes.
I want to talk about first when your sister Miriam became pregnant with Nicole. Do you remember where they were living at the time?
I think it was Texas.
And did you ever meet Nicole's biological father, Ronald Nachtman?
No.
Did you even know your sister was in a relationship with Ronald Nachtman at the time she became pregnant?
I didn't know specifically, no.
So is how the family learns about this individual is basically through the pregnancy.
Yes.
Around the same time, was your sister going through a divorce with Joey and Kevin's biological father, Joseph Carey Sr.?
I'm not actually sure what was going on.
Okay, if you don't know, that's fine.
Right.
You're not sure when the divorce was.
No.
But you're aware that at some point your sister divorced Joey and Kevin's father.
Yes.
After Nicole is born, how old is Nicole the first time you meet her?
I think 2 or 3.
What do you recall about the custody situation or the visitation situation between Nicole and her biological father?
My sister pretty much made it impossible for Mr. Nachtman to have access to Nicole.
Tell me what you mean by made it impossible.
Well, I know that she was.
Judge, I'm gonna draft.
Legal basis?
This is, can we first briefly?
Yes.
Nicole Nachtman from Ronald Nachtman, her biological father.
It seems to me that she spent a lot of time in court blocking.
Judge,
Is
I'm
that-
objecting, not what you observed.
I'll caution the witness not to testify to what you know because someone told you. Only testify to things that you have personal knowledge of, which means that you observed them.
At some point after Nicole's born and her childhood, you had indicated there were times when your mother pretty much raised most of your nieces and nephews.
Yes.
And Nicole spent a significant amount of time here in Tampa in her early childhood years.
Yes.
Whether it be on vacations, breaks, or what
School year too.
and what your sister's attempts at keeping Nicole Nachtman from Ronald Nachtman.
I know there was a lot of court cases,
Okay. And that's again observations because she's got a lawyer, she has to go to court, things like that.
and she told me that's what she was doing.
At some point in Nicole's early childhood, do you recall Joey running away from home?
Yes.
Now, there's been a couple of descriptions about runaway, so let's clarify. Was he like running down the street? Did he jump out of a car? Describe to the jury what Joey did to get away from your sister.
He called me and told me
Don't tell me what anyone told you.
Oh.
Tell me what you did to facilitate him getting here.
I bought him a bus ticket to Tampa,
And where was he at the time?
Texas.
And he was with your sister.
Yes.
And at the time that the family's made aware that Joey now does not want to live with his mom, the family helps provide the transportation to get him here. You.
Yes, me, right.
And where did Joey come when he ran away from his mom's house in Virginia?
But the bus station downtown Tampa.
I meant, where did he finally end up and where did he live for the rest of his high school time?
Initially, he stayed with me and my wife at the time, and then he moved in with my grandmother as his friends lived on that street.
Your mother, his grandmother.
Yeah, his grandmother,
Okay.
which is my mother.
So after he runs away, you get him the bus ticket to come down from Virginia. Now he's a teenager at that point.
He's 16 or 15, yeah, I think.
Is he by himself riding
Yes.
the bus from Virginia?
Yes,
And then never, as far as you understood from your observations here in Tampa, never went back and lived with Miriam again.
he did not.
He then joins the military after high school and is stationed at various locations.
Yes,
So Joey runs away at about 15 and comes to live with your grandmother. Where does Nicole stay at that point? She's 3.
I'm not sure where Nicole was at. It seemed like she was always at my mom's house.
Okay. Do you remember at what point Nicole was, at the earliest age you can remember, Nicole coming to stay with your mom for a significant period of time?
I would say 5 or 6.
And when Nicole would stay with your mom or stay at her house for these periods of time, would your sister be with her or would your sister drop her off?
My sister would not be there.
And for what reason? Was your sister in the military?
Yeah, she was in the military and she was always deployed somewhere.
How often, so beginning at about 5 or
So
6
please
during
tell
Nicole's
me
stay at your mother's house
how
for significant periods of time.
Yes.
Are we
this
talking about
lady
weekends or are we talking about
abused
weeks and months at
a
time?
child
What are we
she
talking
was
about?
never
Most of the time
around.
it was like for the school year.
I would like you to tell me.
And then would there be times where your sister pulled Nicole back and took her wherever she may have been living at the time?
Yes,
Did it appear to you to be a lot of back and forth from with where, as far as where Nicole was living?
yes.
During the times when Nicole stayed at your mother's house, would you say that beginning from 5 or 6, how long did this go on? Did it go on all the way into high school, college? Did it stop? What was the ages in which Nicole lived with your mom for significant periods of time?
I would say it was pretty consistent between that age and age 16. I think when she went to the academy, the Florida Academy.
And we're gonna get to that in a minute, but so pretty much off and on.
See
but for significant
how
amount of
bitchy
time,
this
from about
lady
the
is?
age of
I
5 or
don't
6 to
like
about
her.
16, Nicole is living off and on between your mom's house and with her mother.
Yes,
At some point, does your sister actually give your mother power of attorney over decisions for Nicole?
multiple times.
I mean, you kind of have to do that.
And how
when
do you know
you're
that?
not-
I observed
One.
the form that my sister would give to my mom.
And did you actually drive your mom to the attorney because she can't
Yes.
drive to fill it out?
Correct.
So as far as school decisions, medical decisions, there were times where your mother had power of attorney over those decisions for Nicole.
Yes.
Because you kind of have to do that when you're not in the States or
At any point
around
during
the
Nicole's
child,
childhood, do you
immediately
remember her
around
having
the
friends,
child,
bringing friends over to your mother's house, anything like that?
None.
and
Are
decisions
you aware
have
that
to be
Nicole
made.
went to 13 different schools?
No.
You didn't know a number, but you knew it was multiple schools.
Well, I really didn't know how many schools.
But she didn't stay in one place for a significant amount of time.
I think the only consistency in her life was being at my grandmother's house.
Your mother's house.
Yeah, her grandmother's house, my mom's house.
Now, you said at 16 is the Air Academy. Is that the boarding school that your
Yes.
sister sent her to? And you remember that happening about when Nicole was 16?
Yes. I think she spent 2 years, or it might have been 14 or 15.
Somewhere in those teenage years.
Yes.
And did you voice an opinion as to whether that was a good idea based on what you were seeing with Nicole at the time?
Yes.
What was your opinion?
She was doing well. She was going to church every Sunday. She was in a good environment, and we couldn't understand why my sister would just, and she wasn't even local. I don't know where my sister was, but she was I don't know if she was out of the country or wherever, but called just to have my niece removed and transported to some academy across the state for boarding.
And again, what you knew about Nicole at the time, was she capable of taking care of herself out on her own without the support of the family?
Well, at that age, there was really not much to being that age, because she comes home from school and eats and goes back to school.
But your belief was keeping her in Tampa around the family versus across the state
Right.
would have been better for Nicole.
Yes, yes.
And did you all voice that, or did you voice that to your sister?
I voiced it to my sister.
She went anyway.
Yes.
Did you maintain regular contact with Nicole even after those childhood years that we've talked about, and even into the Air Academy?
She would come home on the weekends whenever she was allowed to.
And when you talk about home, this isn't a home that Miriam Deans lived in.
No, I mean my mother's house.
What changes did you observe in Nicole after the Air Academy?
She started acting more pessimistic. She wasn't as kept as she was before she left. She was really big into like makeup and all this stuff and doing her hair and trying on stuff. And then it just seemed it all stopped when she came back from there. As the weekends went on, she wasn't speaking. She just seemed like she was depressed.
Now, when she would come home on the weekends, she would stay at your mother's house.
Yes,
And you would be at your mother's house and make these observations.
yes.
At some point in 2004, your sister marries Bob. Tell me about that relationship, or what you all knew about Bob. Did you meet Bob before they got married? Anybody go to the wedding? That kind of stuff.
I didn't go to the wedding. I think I met him once before he got married. We went to visit her in Virginia. I can't remember who all went, but we went up there once.
And so, is your understanding that when they met in Virginia and got married in Virginia?
I'm not sure where they got married.
Did you ever see Bob and Nicole interact after they got married?
No.
Do you remember how old Nicole was when they got married? If it's 2004, if you know.
Well, Nicole's a teenager, I think, at that point.
Okay. Any interaction or relationship that you ever saw between Nicole and Bob?
No,
Would Bob come to family functions after they moved down to Tampa?
I think twice.
Okay. Two family
Which is
functions.
not
You know,
uncommon
Bob and
if
his
they
sister
got married
probably
late
married until
and
their death. They got married in 2004. How many years that
she
is?
was already a teenager.
Oh, sorry. At the time of death would be
11?
Yes, sorry.
And you saw Bob at two family functions.
Two.
Now, these times when your sister's deployed or she's going on a work assignment, is Nicole ever staying with Bob at their house in Finsbury and Carrollwood, or is she staying at your mom's?
No, she's not staying with Bob. As far as I know, she wasn't staying with Bob because she would just show up there with suitcases sometimes and
Show up at your
at
mom's?
my mom's house and really wouldn't have an explanation, but Bob was in town
Okay.
at the house.
So Bob lived in Tampa, and yet Nicole was still coming to stay at your mom's house?
Yes.
After, 2004 and
And it
on,
might
are
not
you
have been
aware
their
of Bob ever
agreement that
physically
Bob was
caring for or keeping
responsible
Nicole
for
overnight
Nicole.
if, let's say, your sister had a work assignment or anything like that?
I'm not aware of any time.
Anytime your sister had a work function, she brought Nicole or
Send Nicole.
sent Nicole to
Yeah.
your mom's house?
Yes.
Describe the relationship you observed between Nicole and your sister.
And maybe Nicole was
it
more
was
comfortable
Kind of bizarre.
At
In front of us,
grandma's
it was kind of
house.
lovey-dovey, but then
than she was with Bob.
my sister's had a short temper, so it was kind of limited about how long that sweetness between the two. If Nikki did something that my sister didn't approve of, she would reprimand her right away. It didn't matter who was around.
What did you see as far as Nicole's reaction to her mom?
More of fear. She acted like she was terrified of my sister.
Tell me what the earliest ages you remember observing the fear Nicole had of her mother.
The earliest was during the time of the academy. Those years is when it started.
So 16 or so years
Yes,
old.
yeah.
And when you say fear, can you explain to the jury what you would observe in Nicole to indicate to you that she was terrified of her mother?
Well, everything she confided in me started with "please don't tell my mom" and ended with "please don't tell my mom."
Was that a common phrase Nicole used to describe your sister?
Yes.
Okay.
Yes.
Kids all the time don't want their parents to find out something, or, I don't want them to find out that I spent this money. What did you observe about the genuineness of Nicole's fear of her mother?
Well, it wasn't in a tone whenever she would say things or confide in me. It was not. It was a tone of fear that my sister was going to find out.
Okay.
She was sounded scared. It wasn't like a joking, happy comments. These are "please don't tell my mom," and I could tell it was pretty serious.
And you're a parent, you have a son?
Yes.
How old is he?
21.
Do you recall a time in high school when Nicole had an apartment and lived by herself?
Yes.
At the time Nicole was in high school attending or living in this apartment, was there still a local family living locally here in Tampa?
Yes, just a couple of miles away.
Okay, so this wasn't a situation where there was nobody Nicole could have stayed with?
No.
Are you aware of who got the apartment or what the reason for the apartment was that Nicole was living in during high school?
I don't know the exact reason for my sister to get that apartment, but I don't think she was around.
Again, going back to Bob, is Bob in the picture at this point living in Tampa?
As far as I know, he is.
Okay, so they have the house on Finsbury in Tampa, yes?
Yes.
Nicole's stepfather is living in Tampa.
Yes.
Your mother's living in Tampa.
Yes.
You're living in Tampa.
Yes.
And Nicole is in an apartment by herself in high school.
Yes.
Do you know how long that lasted?
I think that she only went to the high school for 1 year.
Describe for the jury a little bit. You had mentioned the common phrase, "don't tell mom," became, I guess, Nicole's, what she said often. What types of things did Nicole describe to you or did you observe that would result in this fear of her mother?
Well, there were many instances, but basically anytime anything had related to food or please don't tell my mom, but can you buy me some M&Ms or whatever, or please don't tell my mom I broke my phone. Can you help me get another one, or can we go somewhere to get it fixed? That kind of stuff. She was afraid we were going to tell my sister whatever she had done or whatever she was eating.
Tell the jury about an incident that happened at the mall when you took Nicole.
I went to the mall with my girlfriend and my son and Nikki.
Let's put an age or a time frame.
Okay. I'm thinking it's about about 7 years ago. I'm guessing here. A year before the murders.
Okay, and I know it's hard because this happened 4 years ago, but it happened in 2015. When do you think the incident at the mall occurred?
Probably 2014.
Tell the jury about what happened when you were at the mall with Nicole.
Well, we invited Nicole to go to the mall. She had to call home to get permission, so she did go with us. We got to the mall and we're
Let
walking.
me go back a
Sorry.
second. In 2014, Nicole would have been 20?
I think she would, Yeah,
19 or 20?
Yeah, 19 or
In
20.
college?
yes,
And she had to call her mother to get permission to go to the mall with you?
correct.
Go ahead.
So then we're walking down the mall and, we're walking like in a group and we turn around and Nikki disappeared. So we are looking around the mall for Nikki. Can't find Nikki. So I think about an hour or there's a long period of time goes by. We can't find her anywhere. So then I naturally call my sister to find out if my sister picked her up because my sister had this thing about picking up Nikki from wherever we were at and not telling anybody. So I assumed that it would happen and I called my sister and she said she was on her way. She didn't have Nikki with her.
Okay.
So then we finally find Nikki. She's coming from some show they had at the mall. And we tell her that
It's like a glass of water. Sorry, we can get you some water.
I love how those judges always water. Water will fix your crying.
So we find Nikki and we tell her your mom's on her way because we couldn't find you. We're worried about you. And she just busted out crying. Like I've never seen tears shoot out of somebody's eyes the way they did. And we were just freaked out. We didn't know what was going on. She's begging us not to let her go with my sister. And it was just this kind of bawling that somebody was terrified. I mean, like they were going to meet the devil or something. It was just really sudden, and it was so natural, but it was like, it was very, I could see that she was terrified.
And this, you believe, was in 2014, and it was over, just so the jury is clear, her fear that you had called her mom to tell her that she had basically gone missing at the mall.
Yes.
Did you say anything in response to Nicole's reaction to your sister, or ask Nicole, what in the world are you crying? And it's not that big of a deal, anything like that, or any discussion with Nicole or your sister about it?
Well, I asked Nikki what was going on, and she said she can't say nothing. And then I think my
Did your sister show up at the mall eventually?
yes.
Okay. And did you let Nicole go off with your sister?
I asked my sister what was going on, and I said,
Don't tell me what anything your sister may have said, but go ahead and tell us what you said or what you did.
I just basically said what is going on, and that was, it was blown off like somebody's pulling my leg.
So the tears and the fear that you saw in Nicole that day, in your opinion, were genuine?
Oh, yeah.
Around that same time, 2014, and I know you said the changes you observed in Nicole started at the Air Academy about 15 or 16, but describe for the jury what types of things that you were observing as far as your niece's demeanor, her appearance. What are you observing as far as changes?
Well, she wasn't talkative like she used to be. She wasn't all happy, bubbly, putting on a show for people like she used to. She would socialize with anybody. In fact, she would walk off at the park and start talking to strangers. That's how she used to be. Where I would have to go get her and tell her, you can't talk to strangers. You don't even know who these people are or whatever. And she would think it's funny. And so basically, she started not being attacked. She always looked like what I think would be like a battered woman. She always had that, it looked like somebody been pulling her hair. She wasn't putting makeup
I
on
hate
anymore.
to say it like
Her
that,
clothes
but I mean,
were not
teenagers
matching and
teenagers
not
go through a thing.
fitting
I'm not
properly
saying that
for
this one
somebody,
didn't
that's
go through some
young,
things,
whatever.
but their
She would
mood
have,
shift. Oh no!
on their clothing that was basically she would have more than one layer of clothing on.
That
Basically,
she would wear multiple layers.
yeah. I don't know if that was the style or whatever, but it was not appealing
Are you aware about the liposuction surgery when she was a teenager?
after the fact.
And it's not like your niece was ever obese or extremely overweight as far as you could see.
No,
Did you ever smell a body odor or maybe indications that maybe Nicole wasn't bathing or keeping up with her hygiene?
yes,
Did you or your mother, when you would observe Nicole at your mother's house, ever comment on her weight or say she was fat or anything like that?
no.
Who in the family, as far as you know, was concerned with Nicole's weight?
My sister.
At any point in Nicole's life, have you ever observed her responding to things that aren't there, talking to herself, talking to people?
Several times, I would just catch her talking to somebody who's not there, like in a chair next to her. That was pretty much the common thing. I think I caught her twice doing that, and there's nobody there.
Okay. I want to break those times up because one of them is close in time to the incident, but let's talk about the first time you ever saw that and when you think that was.
I would say probably about a year before the incident. It was on a weekend, and she was on a lazy boy that we have in the kitchen area or dining area, and she was talking. She was facing the left, like she was looking at somebody and laughing and giggling and talking. I mean, having a conversation, almost like having a conversation with a little kid. It was just bizarre.
Now, there's been discussions that Nicole was on her computer a lot. Is that true?
Yes.
At this instance, did Nicole have an earpiece or was she talking on her computer possibly, or what did you observe about that?
Well, the computer was folded down, so I don't know if you can still talk to people when it's that much closed, but she did not have an earpiece on.
Okay, so this wasn't her engaging on the computer at all. This was her literally talking to somebody that wasn't there.
Yes.
I'm going to get to the ice skating incident and all that in a minute. But first, let me ask you, in all these observations that you've mentioned, you're seeing in Nicole, she's not taking care of herself, she's not bathing, everything you've testified to. Did you yourself ever express your concerns to your sister?
Yes.
And did your sister do anything about it as far as you know?
No.
No interventions, no counseling, nothing?
No.
Did you ever have power of attorney over Nicole's well-being or anything like that?
No.
See, as far as he knows,
Let's talk about
Nicole did live away from
this summer.
him
Nicole comes August
and then
2015. Did you see Nicole during
for
that
some
summer?
time.
Yes. She was spending
So
a
he
lot of
doesn't
time
know.
at her grandmother's house.
Okay.
Nobody knows for sure.
Was there also a period of time where she went to Washington and stayed with Joey for a few weeks?
I think I'm not sure how close to that was, but it was over the summer at some point.
And then did you see Nicole after she returned from seeing Joey in Washington?
Yes.
And that was at your mother's house?
Yes.
Tell me about any other instances where you saw Nicole either talking to herself or responding to something that wasn't there during that time period or that summer of 2015.
We were going to go ice skating, my son and I and my girlfriend, and Nikki called her mom and get permission to go. So we went to Clearwater Mall. I think that's where it was.
Do you have a time frame just so the jury?
It was in the evening.
No. As far as the days, like how long before your sister's death do you think this was?
I think this is the weekend beforehand.
Okay, so your sister, the week of August 20th, 21st were weekdays. You believe this was the weekend before?
Yes, because she was leaving for school in a couple of days.
Nicole was.
That's what my understanding was. Yeah.
Okay. Explain to the jury what happened.
So she got permission to go, and we went to the ice skating rink, and we had a good time there. We took videos and all that stuff, and then we stopped at I think it was the Wing House I think it was Wing House. We stopped after ice skating, and we're sitting across the table, and then me, my girlfriend, and my son on one side, and Nicole's on the other side with her purse or whatever. I think she was carrying a backpack or something in that seat where she would have her drawing book. Anyway, so we're looking at the menu, and I look up, and Nikki's talking to the chair again. This time, there's no computer. She's just talking to whoever she thinks is next to her.
And do you recall, are you able to make out what she's saying when you hear her
Nikki's
talking?
talking to the chair again,
who she's
y'all.
talking to, anything like that?
No, it's a lot of soft speaking with laughing in between. And okay.
Go ahead.
And I said, Nikki, and no response. I said it like 3 times before she actually turned her face and said, what? I said, who are you talking to? She goes, nobody.
After, let me ask you this. What was your understanding of when Nicole was supposed to go back to FSU that week? Or what day was she supposed to be leaving, if you know?
The next day was Sunday. My understanding was she was supposed to leave for school Monday.
Okay. And at any point, did you talk to her again between the ice skating incident and then when you ultimately learned that your sister and Bob had been killed?
Not between.
Okay. Then at some point, after you learned, and tell the jury how you found out about your sister's death or.
My mom called me, and I stayed at my girlfriend's house, and my mom left me a voicemail. So when I left for the gym in the morning around 6 or something like that, the voicemail said to call her, and I called her, and she told me, can you go by my sister's house to verify that the news is right about my sister? So I go right by there, which was probably about a mile away. And
You see the police and
I see
everything.
the police, and that's when Detective Messer comes to interview me.
Now, at some point, does Detective Messer ask you to attempt to reach Nicole in Tallahassee?
Yes.
And in fact, do you do that? We've listened to a controlled call. The jury's heard it already. where Detective Messer is actually recording a phone conversation that you had with Nicole?
Two times.
And in fact, Detective Messer is asking you to just find out where she is.
He wrote down questions for me, and he told me to just make it sound natural, like you're having a conversation, but try to get the answers to these questions. In fact, it was him and another detective in the backseat. I don't know who that was.
Do you recall who within the family, if it was you, indicated or at first told Nicole that her mom had been in an accident?
That was me.
And that was at the direction of law enforcement?
Yes.
And you in fact did that?
Yes, I did.
Now, at the time you're talking to Nicole and Detective Messer is telling you what to say or recording it, she actually says that she's in Tallahassee. Is that your recollection?
Yes.
And you actually tell Nicole, there's a detective that's going to come up there and meet you. Talk to them, please, Nikki. Tell them, what you know.
Yes, that was the second call. The first call was basically to let her know her mom was in an accident, and she said she had no gas money. So she never really asked what happened to her mom, but she asked if she had no gas money, and then I offered I was going to put money into her bank account to call me back with the account number and all that, and I would transfer the money. That was the first control call.
And then the second one was, hey, tell us where you are. She was trying to figure out an address for her new dorm.
Yes.
Don't tell us what Joey told you, but at some point later in that day, you then get a phone call from Joey who had spoken to Nicole.
Yes.
There's been evidence introduced to suggest that Nicole maybe had not gotten a dorm room in time. Is that something that, in your opinion, based on your observations of how your sister would react to things, how your sister would react to failings or shortcomings of Nicole, that she would have been upset at Nicole with?
Really upset.
Had Nicole not secured a dorm room in time for the fall semester?
Yes.
And
Really
based on the
upset.
observations you have witnessed throughout the years of Nicole, the mall incident,
Super
the fear of
upset.
her mother, is that something that Nicole would have feared her mother over?
Definitely.
Sit back down a moment. Sorry. When was the last time you spoke to your nephew, Joey?
Right after the passing of my sister and Bob.
So you haven't spoken to Joey in 4 years.
Correct.
And as far as your mother, because you lived there at times, correct?
Yes.
The last time Joey had, or how long Joey and your mother had not spoken?
According to my mom.
No, don't tell me
I'm
what
sorry.
someone else told you.
Okay.
Any observations that you made if they were having contact?
Like she's so
Like,
fucking
if
aggressive,
you
yo.
No contact as far as my mom. As far as I know.
I don't have any other questions. Thank you.
All right, ladies and gentlemen, it's close enough to 5:30 that we're going to save the cross-examination for tomorrow morning at 9 a.m. So I'm going to release you for the day. I'm going to instruct you not to do any research related to the case, not to discuss the case amongst yourselves or with anyone else, and also to avoid any exposure to any media or any reports about this case outside of the courtroom. We will start at 9 a.m. tomorrow. All right for
But my position specifically with Martin B.
this case outside of the courtroom. We will start at 9 a.m. tomorrow. All right for the jury.
So we are done with this one for the day.
Jury's exited. Everyone may be seated.
Oh,
You, sir,
now
may
we
step
got
down.
some
You're still on the
stuff to talk
stand
about.
for tomorrow, so please don't discuss your testimony with anyone unless all the attorneys, both sides, are present.
Yes, ma'am.
Oh no.
All right, I'm sorry, Ms. Terry, but there was no way that,
That's okay, Judge. I get no problem.
so we'll pick up the cross, finish this witness in the morning. Ms. Cersei, you had some argument?
I did, Judge, and I provided the cases to the court well in advance, so hopefully everyone's reviewed it. But my position specifically with Martin v. State, which is 110 Southern 3rd, 936, it's a first DCA case. Judge, this case couldn't be more on point with our facts.
But Martin talks about a
Couldn't
condition,
be
there's
more
no
on point.
expert testimony yet regarding any condition of this not mentioned.
No, there's not, but I think we can talk about what, you've read the deposition. I think we can all talk about what's going to be discussed. And this case is absolutely on point in that, first of all, as the state has contended from day one, that insanity and self-defense are in some way inconsistent defenses. This case stands for the proposition that if in fact the experts are going to testify that the delusional thinking of the defendant at the time of the act, somehow due to mental illness, can therefore allow the argument that both insanity and self-defense apply. This case is directly on point. That's the only, I don't think there's going to be a dispute as to what our experts are going to testify to tomorrow. It's clear, they've been deposed, and it's on the record. They are going to testify that her delusional thinking was that her mom was literally going to kill her at the time of these offenses. And so I think it's important to point out, Martin, that these defenses are not inconsistent, and that if in fact the expert on insanity can testify to the delusional thinking or the delirium as it's stated in this case as it relates to the defendant's state of mind at the time of these offenses, the defendant would be entitled to both jury instructions. So I just wanted to start with that case because I know the state's position has been up until this point that our defenses are inconsistent. Then I would point, Judge, to the Spurgeon case, which is 114 Southern 3rd, 1042. And I'll point to page 5, the right-hand column. A trial court's decision to give or withhold a proposed jury instruction is generally reviewed for an abuse of discretion. However, the trial court's discretion is more restricted in criminal proceedings because a criminal defendant is entitled to have the jury instructed on his or her theory of defense if there is any evidence to support the theory and the theory is recognized as valid under Florida law. The trial court, and this is what's important, Judge, because this is what the state's ultimately asking you to do. They're asking you to weigh our self-defense evidence. They're asking you to examine what's been presented so far and for you to weigh what the evidence is. And this case says that's absolutely not what the court should do. That is a jury question, and if there is the slightest evidence of self-defense, we should get the instruction because that's our theory of defense.
What is the evidence, though? That's what, in the cases that they provided, it's not, and now we've backed away from confrontation. It's not her words, confrontation, and even the witness who testified regarding it, he backed off of the confrontation. So the what the F are you doing here is the only evidence that, I mean, correct me if I'm wrong, what other evidence are you relying on to establish some evidence of self-defense?
Judge, there's an open bedroom window that Ms. Nachtman feared confronting her mother so much that she had to jump out of bedroom windows. This is the house she's living in. If they want to, as their argument
But
has been up
did
to this
she
point,
go out
she laid
the
in
bedroom
wait. She laid
window?
in wait. Why not sit right there in the living room as Miss Deans walks in the front door and shoot her right there? That's not what happened. The evidence by the state's own admission is an open bedroom window that it is clear that's the window she jumped out of and then meets mom in the driveway. Her statement to her brother is, I missed time when mom was coming home. We also know that this was quick because when law enforcement gets there, the front door is open. It's ajar when they do their safety check. So we know from the evidence and from the state's own evidence that when Miss Nachtman or Miss Deans gets home, her purse and her items, we've seen crime scene photos, are right there in the dining room and the front door is still ajar. We have an open bedroom window. I would submit to this court that I don't know very many people that jump out a bedroom window, but to avoid contact with the person that, in this case, her mother. There's the incident in the driveway, and what the fuck are you doing here? Now keep in mind, and that's why I cited to the Mobley case, which is 132 Southern 3rd, 1160. The objective standard, and I'm on page 4 of the opinion, is applied to determine, in this case, they're talking about self-defense, but stand your ground, attaches that the objective reasonable person standard by which claims of justifiable use of deadly force are measured should be applied. That standard requires the court to determine whether, based on the circumstances as they appear to the defendant when he or she acted, a reasonable and prudent person situated in the same circumstances and knowing what the defendant knew would have used the same force. So now we have to go into Ms. Nachtman's mind. What did she know at the time? She knew that she hadn't got a dorm. That's in her statement as well and as part of the evidence. And that everyone has testified, Joey, Eric, who knew Miriam Lear or Deans, that if she hadn't secured a dorm, her mother was going to go off and that was going to be a justified reason for her to be terrified of her mother. Remember, it's what Ms. Nachtman knew at the time. She didn't have a dorm. Her mom, she's jumping out her bedroom window. She's coming in the driveway. And in her mind, based on years and years of belittling and psychological abuse and wanting to hide things from her mom and fearing that her mom was going to somehow explode or whatever, that was the fear she was exhibiting at the time she shot her mother.
But do you disagree
Psychological
with me that the person
abuse
still has to do something?
and
If I fear
mental
you, if I have a
abuse is not the
legitimate
same
reason
as
to
physical
fear you, whether
abuse,
it's
and
because of
whether
a mental
you should be
illness or anything else,
for your
if I have a
life.
legitimate reason to fear you, can I shoot you without you doing anything?
There has to be an overt act by the victim. I would submit to you that the overt act by Ms. Deans is, what the fuck are you doing here? That is not, hey, sweetie, you're not in college yet. You missed your time to leave. I would submit to you that in Nicole Nachtman's mind at that time, who we've heard was like a child, who we've heard couldn't take care of herself, who we've heard, again, it's an objective standard, but in the circumstances as Ms. Nachtman knew them. So we're now her testimony that she was childlike. She loved Elsa. She loved Frozen. She couldn't bathe on her own without somebody telling her. She couldn't wash her clothes. She didn't know how to cook. So now you have this child. Don't look at her chronological age of 21. Look at Ms. Nachtman and what you've heard testimony of people who knew her at this time and described her as. And her mother says, what the fuck are you doing here? That is not an invitation to, hey, honey, let's go talk. That's the evidence of self-defense. I'd submit to you, and I'd argue simple, which is the case that says it's the slightest evidence of self-defense, and it's not for the court to weigh the evidence. If we've introduced any evidence of self-defense, we're entitled to the instruction. For the record, simple is 972 Southern 2nd 912.
Mr. Terry, how do you suggest that you get around Martin versus State?
In Martin versus State, Judge, you have independent witnesses who observed them coming onto the property, okay? The defendant in that case is heard yelling, get off my property, I'm going to get guns. So there's clear evidence in that particular case that that defendant is in fear and is responding to outside stimuli.
But they're
You have
uniformed
witnesses.
police officers, where a normal person wouldn't be able to justify those thoughts in self-defense. But the court in Martin says that because of his mental condition, even police officers coming to his house to arrest him or for whatever reason they were there, support it.
Correct, but there is overt actions. There's testimony from independent witnesses to what occurred. There's testimony that the defendant was clearly in fear at that time about people coming onto his property. So there is evidence that's been put in. The only evidence suggested here is the mom saying, "What the fuck are you doing here?" Which is what, I don't know how that's an overt act. I don't know how that's a forward-thinking act.
So is it your opinion that is it your position that the opinion of the first district in Martin would be different if the police had just showed up and said, "Come out with your hands up," as opposed to "What the fuck are you doing here?"
Correct. Correct. In his reactions beyond that, and the fact that they came on the property, there's all sorts of differences, Judge. And beyond that, let's not forget the next statement that she gave to her brother. "I blacked out after that." So we don't even have her admitting the shooting or acknowledging what her mom did or what she did as a result of it. So she blacks out. I provided Your Honor a case. I don't have them all in front of me because I wasn't.
I read them. I
arguing
have
right
them
now.
here.
But there's a case where
He just says it's self-defense.
it says
and they
it's
come
self-defense,
up,
but he
and that's not
blacked
enough.
out.
But there's nothing in that regarding, like in Martin, such a severe mental condition of the defendant in that case. And I agree with you. That's all they had to rely on was he says to the police, it was self-defense. And the court says that's not enough. But there's no discussion in that case. Had he had schizophrenia or had he had delusions and all that, whether it was self-defense, I still don't think that it would have been enough in that case.
Judge, my position on the circumstances is, again, taking into account the dorm. And again, the reasonable objective standard in somebody in Nicole Nachtman's position, the reason for the dorm, the comment about if I'd only got the dorm information, you have to take it all, the totality of everything that's been presented. We know she didn't have a dorm. We know that from the paperwork. We know that from the housing. We know about when she got the paperwork. And every person that knew Miriam Deans and Nicole Nachtman said that in Nicole Nachtman's mind, that was a legitimate reason to have feared her mother. So there isn't just the overt act of what the fuck are you doing here, but there is that mindset of Nicole Nachtman. And again, our experts are going to testify tomorrow that her schizophrenia, her delusional thinking, her paranoid thinking, she literally thought her mother was going to kill her at that moment. And that in and of itself explains how, or puts into context, the dorm room and how she really thought her mom was going to kill her. And so I think you have to look at it in the totality.
And Judge, I agree. Let's look at it in the totality. The totality is that she had the chance to leave that place long before her mom ever arrived. She was on the phone with her mom just before her mom arrived.
Yes, she
Correct.
did.
Anytime she was so in fear and so afraid of her mom.
Yes, she
She not only didn't leave, she moved her car so her mom wouldn't see her car there. She still waited at the house for hours for her mom to arrive. This is not a woman who was in fear. This was a woman who laid a trap. All the evidence suggests this is premeditated, first-degree murder, luring a mother in. There's nothing to say that she just happened to be sitting in the house, not knowing her mom was coming, with the car there. The mom walks in and says, "What the hell are you doing here?" And then suddenly she gets freaked out.
And
So we look at the totality of the
the court
circumstances
reporter
as
can only take down one.
so if we look at the totality of the circumstances, she's suggesting that there is absolutely zero, zilch, nothing of self-defense. And there's no way, Judge, if we're going to take a statement by an individual of what the fuck you're doing here and turn that into self-defense, then we're going to have self-defense cases all throughout the circuit constantly in any case. Because that's just a statement. It's not an overt act. She was confused. And Judge, you don't have the benefit of this, but the statements that she's made to the psychiatrist in this case, the doctors in this case, is that the mom looked like a deer in headlights. Where's the self-defense there? The mom's like a deer in headlights. She's like, "What are you doing here?" So again, there's no overt act.
And those are obviously arguments, if I allow it. I'm not saying I'm going to allow it. Those are obviously arguments you can make to the jury. And if there is no evidence of it, I mean, the jury's going to be instructed on. My concern is if I don't allow it, and I should have, we're going to do this case again. Now, that doesn't mean that just because of that concern, I'm going to give them something that they're not entitled to. I'm telling you that it's close. And Martin, and I hear you. But now, and again, even whether I agree with Martin or not, I've got to follow it unless you have something. I understand the case that you want to rely on, the second DCA case. And when I read that case, I was with you. But that case doesn't have the mental illness like Martin does. So if you have something else that brings in the mental illness, then I'm willing to consider it. I'll give you time until tomorrow. But I want to address because my concern too, I share your concern that if this is an open door, just anybody can come in and claim self-defense if they fear somebody. But that's not the case. It has to be somebody in the same situation as Ms. Nachtman and anticipating the testimony of these experts. But I haven't heard, I read the deposition of Ewing, I think is his name. But I apologize to you not being able to give you, I need to hear it. And I need to hear the cross-examination of him before I'm going to be able to decide this. So I'm not giving you an answer today. And I know why you wanted it, because you want to have time to discuss with her decision whether to testify or not.
Yes, sir.
But I don't know why you can't have a conversation with her about if the judge rules this way or if the judge rules that way.
Well, because how we would have presented our case would have likely been Ms. Nachtman before the experts, just to indicate, a basis for their opinion and to kind of put them on after her would be the position. Judge, I want to point one other additional thing. I know the court has to go. We also have information about the close range firing of these. And we know from Dr. Krasowski that one shot is, and I demonstrated, was less than 2 feet away from muzzle to wound. And that the other two, all he can tell us is more than 2 feet away. And so I believe that that's also evidence to show this wasn't a football field distance. She wasn't at one end of the driveway and the other end of the driveway, that these were within 2 feet of each other, one closer than 2 feet when she shot. He can't tell us the order of the gunshot wound, so he doesn't know if the one that's less than 2 feet is the first one. What the fuck are you doing here? And there's an open bedroom window that the evidence has indicated Nicole Nachtman got out of to avoid her mother, not laying in wait for her mother.
So you're relying, let me see if I can summarize it as
But
this
the
way.
TV
You're
was on
relying
and
on
there was
that
chips
the close
by the
nature of the
TV.
contact between her and her mother, in addition to the mental state and the statement of what the fuck are you doing here?
Yes, sir. And Judge, and I understand we have not presented Dr. Ewing, but as I stated before, based on the deposition that the court has reviewed,
what was
to
she
indicate what his
doing?
testimony
She
will
was
likely
just
be, it
chilling?
is going to be that she literally feared her mother because of the delusions, because of the paranoid thinking, because of the
Then
abuse
she
had
should have
suffered for
left the
years,
house.
And that is exactly in line with Martin v. State. And based on that, we'd ask that you grant our request for the self-defense instruction. And like you said, the state can sit there in closing all day and argue why it's not self-defense, but that's not the standard as to whether we get an instruction on the law or not.
And let me just make sure I'm clear. You're not asking for self-defense as to Robert Keys.
Correct.
And Judge, lastly, Martin v. State, I do believe, Your Honor, if you read the facts and look at the facts compared to this case, it is different. It is different because these officers were approaching him. He was making, and all these officers testify that, he was making threats, telling them, get off my property, I'm going to get guns. That's a lot more evidence that this person was in fear, that he was trying to defend himself. That's a lot of evidence to suggest that. Now, granted, the mental state gets to the next level of saying that's why he didn't realize they were uniformed officers, so he was in fear. But regardless of that, the fact that they were advancing on his property, the fact that he was yelling to them, I'm going to get a gun, get off my property, adds to, that's a lot more evidence than what we have here, a lot more. And if you read the rest of her cases, they all have a lot more evidence than what just his words of what the ever you doing here. A lot more evidence.
And Judge, I would just point out, as in Spurgeon, it's not for the court to weigh the evidence, that's for the jury. The issue is, are we entitled to the instruction? And
I agree with you. There's some evidence. The evidence is the close range, the what the fuck are you doing here, her mental condition. I'm going to allow it.
Thank you, Judge.
See you at 9 o'clock.
Well, damn. Was it self-defense? No, it was not. Was she crazy? No, she was not. I don't believe
She
was.
within 3 or 4 at the time.
Correct.
And
Oh,
Joe
dear.
never indicated to you that Nicole witnessed it, did he?
No.
I think where we left off yesterday is we had a witness on the stand and we were going to begin cross-examination.
Judge,
Yep.
we are going, based on the court's ruling late yesterday afternoon, after that witness began his testimony, and Ms. Derry, I asked if she preferred I address it on redirect or reopen my direct examination with your permission. She said she'd rather reopen my direct. So the issue will now become, because of self-defense, whether he can testify to specific acts of violence by Miriam Deans that Nicole Nachtman knew about. And Ms. Derry and I just went out together and spoke with him and confirmed what his knowledge about that is. I provided the cases to Ms. Derry, which allows for this type of testimony. I'm not sure if she's objecting, or if you want copies of the cases, Your Honor, to review.
So I don't have, you need to give me the cases. It's not in this. I have stacks of cases up here. I have the last stack I think you gave me is defense JOA on self-defense. So I don't have a stack of cases that I should be looking for.
No, you do not.
Ms.
You will in about 1 minute.
Well, let me see. Ms. Derry, you had an opportunity to look at the cases?
Yes, Judge, I have. And so here's my objection to this. Ms. Hersey's director and I went out today and we talked to Eric about it, about what he knew of Nicole knowing about it. So the court understands what we're talking about. We're talking about specific instances of abuse by Miriam Deans against Joseph Carey. The state's objection is that Eric Lair was not present for when these acts of abuse occurred. He heard about them subsequently by Joey telling him about them. And then what he's going to say, based on what he just said outside, is that I assume Nicole knew about them because the family would talk about it. He is not able to say that he was specifically present when Joey told Nicole. He's not able to say that he recalls that Nicole told him, I know Joey, this happened to Joey. So my objection is that I think it's all based on hearsay. His knowledge of it is only whatever Joseph Carey told him. He did not witness the abuse himself, nor did he specifically witness when Nicole was directly told of the abuse. So that's my objection to it. I do not disagree. I mean, I've read her cases that it's recognized that when the defense of self-defense is raised, evidence of the victim's reputation may be admissible to show his propensity for violence and the likelihood that the victim was the aggressor, while evidence of prior specific acts of violence may be admissible to show the reasonableness of the defendant's apprehension at the time of the slaying.
But that assumes that the defendant knows of.
Correct. And so my position is that at this point, I think it's too attenuated. I think there's too much of a stretch at this point, and especially since he didn't witness it, and he didn't witness when she was specifically told about it. He just assumes that she knew.
He's simply speculating that she knows about it.
Correct.
Judge, that, first of all, I suggest that we proffer his testimony on this issue. It's going to be brief. He actually witnessed the injuries. He didn't witness, most abusers aren't.
You though, not her. But how does that bridge the
Well, I
gap
want to
from
fix what she said
his
about
knowledge to her knowledge?
I want to fix what she said
I'll
about the
give you that.
basis of his knowledge. His knowledge is he witnessed injuries. Most abusers aren't going to abuse their children in front of someone or have a witness present. And then he's going to say the family discussed this over the years. In fact, at the time Joey ran away, where Mr. Lear has already testified he bought Joey the bus ticket to come down here, he was fleeing abuse, and that Nicole was around at the time and was aware that that was the reason he was fleeing. And I have cases here that
But
show
is she?
basis.
She's 4.
He said the family discussed it. It was happening in the home.
Well, bring it in. Let's see if it sounds like it's a assumption on his part and speculation on his part from what I'm hearing from even both of you. Let's bring him in and
And I do want to also point out, and I want to cite Nelson v. State, and I didn't give this one to you, Mr. Aaron. So just for the record, cases are Williams v. State, 982 Southern
And I'm
Second,
not
1190.
saying
Quintana
that
v.
4-year-olds
State,
are
452
not
Southern Second, 98.
aware of
And then
things.
Nelson, which says that hearsay, reputation
But
evidence
are
can't
they
come in
aware
through
of things?
hearsay testimony. It does not
All
have to
the
have
time.
been personally observed, meaning Nicole Nachtman didn't have to witness the abuse. People could have told her about it, and that's sufficient.
but there has to be some evidence that she knew about
It
it,
is.
not just I believe she knew about it, I think she knew about it, I assume she knew about it, she should have known
Fucking
about
put
it.
your
She knew
defendant
about it
on the
because I
stand
told her
and
she knew
fucking
about it
ask
because
her.
she was there when we discussed it.
Yes, sir.
And then
I
we
can
don't have to
list those
sit here and
questions
argue
for
about
Mr.
this shit.
And Nelson is 739 Southern Second, 1177.
Sorry, Mr.
I have
Chair.
copies for you if you want them.
I want to correct one thing
Yes.
that Ms. Hersey just said that I found out about last night subsequently.
Yes.
Mr. Carey called me and indicated that Eric Lair is incorrect about the running away. He never ran away from his mom. The time he got the bus ticket from Eric Lair, he was running away from Texas. His mom was already in Tampa. He was running away from Texas where he was being abused by his father. And he was having to be there on an extended summer visitation. So that's what he was running from, not from his mother. And so to say that they were discussing it because she was abusing him and that's why he ran away from her, he never ran away from his mother. He stayed in Tampa when she was moving to Virginia because he didn't want to go there. But he never ran away from his mother. He ran away from the father. And I intend to call him in rebuttal to bring that up to explain to the jury the actual circumstances. It was his life. He remembers it. And he knows exactly what he was fleeing from. So I wanted to correct that for the record and let the court know that we intend to bring him back on rebuttal to explain that situation.
Well, I appreciate that because there was some confusion in my mind from when he testified and then from what was explained subsequently. And I was confused as to whether I got the impression he had run away from Tampa from his mother. But if that's not the case, then.
He ran away from Virginia and Tampa, and his sworn testimony
Wait, you said Virginia and Tampa or
No, he
Virginia
ran away from Virginia to
to
Tampa,
Tampa?
got out of the car. Well, Mr. Terry, when he asked him, you didn't really run away, like we made this big issue about the word run away, he certainly wasn't staying in the home. And Judge, while we have this discussion, I'd ask that Mr. Terry not be in the courtroom.
That's fine. I'll ask him to step out just till we continue this, finish this legal argument. Thank you, sir.
Sworn testimony under oath at a deposition and at the battered child syndrome hearing is, he ran away to get away, and I asked him on cross yesterday, he ran away to get away from the stress and turmoil that was happening in his household between Ronald Nachtman and his mom's volatile relationship and the divorce that his mom and his father were undergoing. That's his sworn testimony. He may now want to couch it in terms of, I was running away from my abusive dad, which again, we weren't able to get into because the state objected that that wasn't relevant. But his sworn testimony is, I was running away to get out of that household that involved his mother, who was going through a custody battle with Nicole's father, and going through a divorce by his biological father. That is what his
Those
testimony.
sound like cross-examination questions, and those are things for the jury to decide, not me.
Absolutely.
Just like the self-defense thing, I'm not deciding that it's, just that you can argue it to the jury and they can decide it. I'm not deciding it. So I appreciate that information, Mr. Terry, for the benefit of everyone, and decisions can be made, down the road as to whether, that's necessary, not necessary.
Judge, I don't know if you want to do Eric Lear or what order, but the other outstanding issue is we have my motion in limine as to the expert testimony, and because the experts are going to happen today, all of them, I prefer that we have a ruling. And I think when Mr. Terry and I initially talked about it earlier in the week, or last week, I think he was under the impression that I wanted Dr. Lazaro prohibited at all from talking about what Nicole told her about the offenses. My request in the motion in limine was that she not be able to characterize anything as a lie.
Right.
That's improper for an expert to do. It's improper for the jury to hear her opinion. She can testify, and I clarified it with Mr. Terry, so I'm not sure what his position is on the motion now, after we talked about it on Monday or last week.
Proper.
She won't, I'll instruct her not to say lie, but she can say that there was inconsistent
Absolutely.
statements. She can
Well,
say-
it's not consistent with the evidence, and that was my thinking when I read it. Can't say, because she's not an expert on credibility, but she can say what she reported to me is inconsistent with what, I know about the case, the police reports, absolutely, inconsistent, but not say, in my opinion, she's lying about this.
And I will advise her of that, Judge. I don't have any objection to that. I will
So
advise her.
Judge, that covers, just of my motion, I don't know if it's in front of anyone, that covers paragraphs A through F.
In my opinion,
G,
she's a
Dr.
lying
Lazaro,
liar
despite
who
has not
lies.
been participating in a 14-hour evaluation, opined that she believes my client was being uncooperative during the evaluation because she was lying. Again, uncooperative and not answering questions.
The conclusions, she can testify to observations that she made. I asked her questions and she refused to answer those questions.
But
Absolutely.
to say she's uncooperative because I think she was lying, which is how she testified in deposition, I'd argue should not be allowed.
That's fine, Judge. Don't-
So
Right.
G,
There was something about grandma too.
H was Dr. Lazaro testified that she believed that Ms. Nachtman was hoping the interview on the second day wasn't going to happen and she wasn't going to have to do another interview. There was no such word
Sounds-
uttered.
Speculation. I mean, Mr. Terry, did you?
I don't intend to get into that.
All right. So she won't testify about that. If she thinks that Nicole thought the interview was going to end on the second and it went into the third day, we won't go there.
She opined in deposition that the defendant lied about how well she really did in school. Again, she wants to talk about school records she reviewed and what the grades
She can
showed.
testify. Nicole said that she was doing great in school. However, her report card has F's on it. But to say that she was characterized it as a lie, she can present the facts. The jury can decide later whether she was lying.
That was I. J, when describing an incident at graduation, where Ms. Deans pulled my client to the side, Dr. Lazaro indicated, again, she did not believe that that's the way it occurred, the way the defendant described. Obviously, Dr. Lazaro was not at Nicole Nachtman's graduation. So to characterize, again, anything my client is relaying about instances with her mom, to characterize that she believes or disbelieves any of it is completely inappropriate.
What's your position on that one?
Well, Judge, one of her positions is that she's malingering. And by malingering, she's not saying that she's malingering any mental symptoms. What she's malingering is the amount of abuse and what she suffered. And so in order for her to give that opinion, she needs to state that she does not believe it occurred the way Nicole was describing. It does not sound right. And so that's part of the entire
Doesn't
malingering
sound
aspect. And I think she should be allowed to
consistent.
testify about that. Obviously, she won't say she wasn't lying, but she can give her opinion as a certified licensed psychiatrist that she believes that was not how it happened.
Judge, the way malingering works is she can testify to a test she administered on malingering. She can testify to the questions that she asked Ms. Nachtman and in what areas she scored in malingering. But again, we're back to square one where she's now going to characterize Nicole's reports of abuse as, I don't believe that it happened that way, when there's no evidence to suggest that that opinion is true. Her opinion on malingering can absolutely be based on tests she administered as it relates to malingering. She can testify to the score. She can testify to Nicole Nachtman malingered here, didn't malinger there. What she cannot do is say that anything my client said, unless Dr. Lazaro was at the graduation, that report is false. Unless, again, back in the records or the family's accounts are different, she can talk about inconsistencies and maybe how that incident happened or how Nicole described it versus the records. But to opine that she doesn't think she's telling the truth about how it happened, where's that coming from? That's not based in
Well,
any
your experts
expertise.
weren't there when Nicole shot her parents, and they're going to make opinions about whether they think she was in fear or whether they think she was hallucinating at the time, but they weren't there. So how about if I preclude those opinions?
Based on words my client uttered, that's their opinion. Dr. Lazaro's belief that it didn't happen isn't based on anything. Nicole said it. If Nicole had said it didn't happen, or if Nicole,
It has to be based on something. She didn't just come in there and say, I mean, it has to be based on something. I mean, if not, then hey, cross-examine the heck out of her on it. That's what cross-examination is for. If that's what she says.
That's very
I
true.
don't
That's
even
a
have
good
to wait.
point.
You get
That's
up and you
very
say, "What's that
fair.
based on?" She says, nothing. Oh, great. That's a score for the defense.
Well, but the jury has now heard an expert psychiatrist's opinion that she doesn't believe my client's account.
And
Again,
now
it goes back to
cross-examination, they heard that expert say that my opinion is based on nothing.
Okay, so you're
I'm
denying
gonna
it
allow it.
as
Yes,
to
you
paragraph
cross-examine
J.
her. You cross-examine her on it.
Okay, so right now we're on A through I. My motion to eliminate is granted, Your Honor.
Yes,
J, it is denied.
yes.
Paragraph.
Well, wait, partially. She can't say, use the word lying. She can say that it's inconsistent. She has to base it on, she has to explain why. Do you understand that, Mr. Terry?
Yes, sir.
Paragraph 15 in the deposition indicated she was unable to diagnose Ms. Nachtman with antisocial personality disorder because she didn't meet the criteria. She then gives an explanation. Oh, she didn't meet the criteria by one thing. This jury shouldn't hear antisocial personality disorder at all because she can't diagnose it because she doesn't meet the criteria. It's prejudicial for an expert to be able to say, well, I think she was antisocial in A through G, but I didn't diagnose her with that because she didn't meet F. It's prejudicial because she can't come up with that diagnosis. So any mention of
I
any
mean, she
antisocial
met
personality disorder is irrelevant, and it's not her
99%
opinion.
of
But
it.
at the end of the day, I mean, she's saying that she's not. She doesn't have that.
She is, but I don't want the jury to hear antisocial personality disorder at all. It has a negative connotation, and if she's not diagnosing her with it, what's the relevance?
Does schizophrenia have a negative connotation to it? I mean, your experts are going to say
She's
she's
going to say
schizophrenic.
schizotypical. She's going to say she's on the schizophrenia spectrum. So everybody's on the same spectrum. We're just a little off on the spectrum.
She needs to be able to give her opinion as it is and say,
Well, but
this is what she met all of these criteria but one. So while I believe that she may be, but I can't absolutely say for certain she is. But I mean, these criteria, Judge, are very flexible, very hard to pinpoint.
Mhm.
As you know, they're all like 8 criteria, should meet 3 of them.
so essentially, that's she's said it's not black and white.
It's not like, right, she's not gonna say that, but she can say that she meets some of that criteria for that.
So she
Incorrect.
thinks that she still might be, but because
I mean,
what the defense is telling you is
from the deposition that was a while ago, so
That's
I don't remember
incorrect. She didn't
exactly
say it was
what she
fuzzy. She cannot diagnose her with antisocial personality disorder because she did not have a conduct disorder before a certain age in childhood. That is her testimony. She is not antisocial. So to then say, well, I looked at antisocial personality disorder, but I can't diagnose her with that because she doesn't meet it's a requirement for antisocial personality, that you have a conduct disorder at a certain age. She admitted in deposition that that is an actual requirement before the diagnosis can be made. And I'll quote the exact deposition, page 117. Do you believe for malingering I asked, because did you diagnose her with antisocial personality? Let me say something about that. No, she didn't meet antisocial personality criteria only for the reason that you need to meet the criteria for conduct disorder as a child. That's what Dr. Lazarus
Well,
said.
Judge, it sounds like she's not gonna say it. That was in response to their question, whether she asked it. So
so you don't intend to
I don't
elicit.
intend to ask it, so
Oh,
I mean,
that's the question. I don't want it mentioned at all.
I have no intention of asking her. I'm merely gonna ask for her diagnosis and what she found. And she gave like, I believe 6 of them, and I'm gonna go through each one and ask her.
Obviously, the deposition is much broader than things she may testify to here. Sounds like during the deposition, the defense was going down different avenues and different doors were closed. If that door was closed as the antisocial personality, then I'll instruct the state not to elicit that.
Well, and it sounds, and I won't, but that sounds like it was. I didn't know, Judge. It's been a while since we've done the deposition. We've done so much since then, so. I
So
wasn't
granted
sure.
as paragraph 15 here?
Yes.
16, during the evaluation, well, let me ask you, are you intending on asking her about watching this series that my client liked, this television series? She indicated it was not relevant to her opinion. The term, the TV series in and of itself in the title, I didn't want mentioned unless she was
I think
relying on
what
it.
Terry's indicating he has no intention.
Granted as to 16. And then
What
final
was
one
the
is
television
information about the grandmother.
series?
And again, our position on Miriam Lear is Dr. Lazarus did 2 interviews
Not
with family
fair.
members, the grandmother and Joseph Carey. And when we deposed the
I
grandmother
wanna
right
know.
after the interview, shortly after, about a week after, I think it was, and asked her the facts that she relayed to Dr. Lazaro. So, for example, Dr. Lazaro says you told her this. She has absolutely no, she's 88 years old, or 89, I think the testimony is. Obviously, the state has chosen not to call her as a witness.
That's
to lay
why
any
they didn't
foundation for that
call
opinion.
Grandma.
So we'd be arguing that would be hearsay. Had they called Miriam Lear and she had testified to
Might
whatever
have
she
some
remembered, or
memory
was even as we
issues.
sit here today able to remember it, my argument would be different. But because she wasn't called as a witness and has no recollection of the information she shared with Dr. Lazaro, we'd ask that she not refer to that interview at all.
Judge, I believe she should be allowed to refer to everyone she spoke with and informing her opinion. Whether or not Ms. Lear remembers things certain days.
I
or doesn't
switched
remember
my
certain
internet
days, I
around
believe
and
materials
it's
what Dr.
still,
Lazaro heard and based her opinion on. And I believe she's merely going to testify that in speaking with her, that Ms. Lear did not notice any problems with Nicole that drew her attention, or did not see any negative relationship between the mother and Nicole. That they seem to be getting along fine. In fact, she described, and she also, I believe, described this in the deposition as well, that just right before then, like the week before, she remembers them both being in the house, and that they were sitting together on the couch, and Mary was sitting on the armchair next to Nicole with her arm around. They were laughing and joking about stuff. So, and she said that in the deposition as well. She did remember that. So that's one of the things Dr. Lazaro relied on. So I believe she should be allowed to at least testify about it if they want to get into the fact that, whether mental situation as they can.
Well, Judge, it goes back to the argument they've been making about our hearsay information. You know, they don't have a right to confront witnesses, we do. So if you allow Dr. Lazaro to be a conduit to Miriam Lear's information, we didn't have an opportunity to cross-examine Miriam Lear on her lack of memory now because Mr. Terry didn't call her. We can't call her to impeach her. We can't call her to say, hey, you don't remember anything. He doesn't have a right to confrontation. We do. So now to allow Dr. Lazaro to be the conduit to Miriam Lear's hearsay is a violation of Ms. Nachtman's confrontation rights because now it's left for the jury. She told me all this stuff, and a week later when I deposed her, she doesn't remember anything. That's the
All
violation.
right, but the doctor should be able, if the doctor took it into consideration, the doctor should be able to allow to say, I spoke to A, B, C, and D, and based on what they told me, this is my conclusion.
Fine, but to talk about the
Well, it's
hearsay
not
that was then relayed to her
fair
that has not been
that
established
grandma
violates Ms. Nachtman's confrontation rights.
might
Judge,
have
I don't know what she's going to testify about that because she was never asked
the
questions about that in the
dementia.
deposition. I don't know I don't
So,
necessarily intend to elicit anything more than just
excuse
who she
me.
spoke with, and that's it.
And, well, and I'm gonna allow that, and you're entitled to that. Now, if here's my ruling, she can't get into specific statements because I think that those are most likely hearsay, and I know that the case law says the expert can't just be a conduit to hearsay. Now, if there's some other exception to those statements, then I would be happy to consider them, but I haven't been presented with any. So for the doctor to come up here and say, grandma told me, quote, whatever, that's, I'm gonna sustain or grant the motion against that. But as to the doctor talking to her,
Grandma said.
basing her opinion on what the grandmother told her, absolutely.
Thank you, Judge.
So,
Yes.
Judge, I'm obviously going to need some time to speak with Dr. Lazaro about this case.
Well, she's not being called right now, is she?
No, she's not. She's not.
Yeah.
But two other matters were.
We're being optimistic that we might even get to her today.
I believe that is going to be optimistic, Judge. But two other matters. Number one, I've informed Dr. Lazaro of the rules. She's aware of it. She has not been watching any testimony. But what I need to know is she has asked me because, as Your Honor's going to find out, Dr. Heidi is changing her opinion on insanity. Obviously, I never got a chance to depose her about that. I never found out why she changed her opinion, or because I found out about this literally on the Friday, the eve of trial. I received a phone call from Mr. Fulgaro. So I'm kind of going at this blind myself. And Dr. Lazaro would love to know, or is curious to know, why she changed her opinion, what she now truly believes.
She's entitled to that.
So she would like to watch that online wherever
She's
she's
an
at.
expert. I don't, the rules, the expert can sit in here and watch.
Yeah, I don't think that's precluded
Yeah.
by issue on the insanity, and we might as well address it now. Just so the court knows the sequence of events, we filed a notice of intent to rely on insanity, which we're required to do by Rule 3.216. The only doctor we listed to elicit an insanity opinion is Dr. Ewing. Dr. Heidi, in a battered child syndrome hearing, was asked one question about her opinion on McNaughton, and she indicated no. In trial preparation, in discussing Dr. Heidi's testimony, and in reviewing the jury instruction with her on insanity, she indicated to me that she, under McNaughton, would have believed Ms. Nachtman, and I'm paraphrasing, I'll let Dr. Heidi testify, that under McNaughton, yes, she believed she knew it was wrong, but she was going to discuss the consequences. Well, I didn't amend my notice. I do not intend to elicit an opinion on insanity for Dr. Heidi. And I let Mr. Terry know that because of the late time in which I found that out, I was not going to then amend my notice because we have time period constraints on when we issue a notice of intent to rely on insanity. So I do not plan on eliciting that opinion. As my ethical obligation is, I let Mr. Terry know because I didn't want him to ask her and be surprised if she changed her answer. But I don't intend on eliciting that, and I don't believe it should be asked by Mr. Terry. I have a notice requirement as it relates to insanity. I would have added Dr. Heidi if I had not found out the week before trial, and I didn't. I don't plan on even asking her about insanity. So to then now ask her about insanity on cross, it's beyond the scope of direct pay, or will be at that point, because I will have not elicited an opinion, and I purposely didn't put her on the notice because of the late hour in which I learned it. But as my ethical obligation is, I let Mr. Terry know, so he wasn't surprised by that when she testified.
Yeah, well, she's, I don't find it beyond the scope. I understand it. Technically, it's a different, legal term of art as to insanity, and I don't mean to over generalize and say that they're the same thing, but she's talking about the same issues here. So I'm not going to preclude the state from asking her that on cross. Now, what I'm going to ask is that you make her available to them. I know it's not a deposition, but allow the state an opportunity to talk to her before she testifies.
Because I never precluded that.
About that. And also, absolutely, Dr. Lazaro can either come down here and watch, she can watch on the live stream, but she can watch the other experts testify. Both of them, yes.
I'll let her know, Judge.
And there's no objection to that.
Judges or experts are allowed to sit.
And then there's two other matters with regards to the expert's testimony that are just very briefly, two things that I want kept out. Number one, Dr. Heidi, when she testified previously, Judge, in Your Honor's courtroom, she stated
Let's
that.
let the other witness know he can come back in.
Mr. Terry?
Yeah, I don't have,
Do you want him out to an error proper?
Yeah, it's
Judge,
different
let's
than
leave-
that.
Oh,
I'd rather
all right, that's fine, that's fine.
Judge, I would ask that Dr. Heidi be precluded from discussing any prior abuse done by allegedly done by Mrs. Deans against Joseph Carey. And I would point your honor court to page 60 of the transcript of proceedings before the court, and where she talks about those issues. And obviously we were in a court with you, Judge, so I was not going to necessarily object at that moment. But even talking about Joe being, talking about Eric Lear's testimony, is kind of fitting that we're actually talking about it. She describes the abuse that Eric Lear talked about, and she then indicated, so that data, though not directly relevant to Nicole, certainly indicates behavior that I would consider to be physically abusive towards, in that case, another child. I would ask that she be prohibited from discussing any evidence she knows or has heard about or read about regarding any alleged abuse between Miriam Deans and the other son, or Joseph Carey.
Okay.
And then the other thing is on, in Dr. Ewing's deposition, he mentions, I'm trying to, I'll see if I can find the exact page number, but he mentions in that deposition that the mother obtains a gun and tells Nicole that she got the gun because, according to Dr. Ewing, which I guess he received from Nicole Nachtman, Black people were moving in the area and they needed it for protection. We would object to that statement.
Nicole reported this to Dr. Ewing, that her mother got the gun for that reason?
Correct. I'll see if I can find the exact page number. I have it written down.
And you want to preclude any?
Judge, I believe the court, I'm not so much about the gun, but the purpose of the gun.
Right.
Let's find the page number. That's on page.
Ms. Hershey, did you intend to get into the specifics of?
I don't think the reason she got the gun is relevant.
All right, that's the thing.
Yeah.
So Ewing cannot testify to anything that Nicole told him about why her mother got the gun.
But just that she got
She
it.
got a gun. Even she got a gun for protection, but not the specifics
Right,
of.
not the specifics, because the safety is overly prejudicial. And that was all I had.
I would agree. I would agree.
Judge, the issue on page 60 about abuse, Dr. Heidi's comment that it's not relevant to her opinion on battered child syndrome doesn't mean it's not relevant to the issue of self-defense, and that's for the jury to decide. So I don't believe that while she may have testified, when she's testifying to whether something's relevant, it's her opinion as to battered child syndrome. She shouldn't be precluded. If in fact we can establish that Nicole Nachtman knew about these specific acts of violence and they come in, I think she can testify to records she reviewed to corroborate it, if I can establish it.
If you can establish that Nicole knew about them,
Absolutely.
that's a different story.
Yes, sir.
But we haven't established that.
Yes, sir.
So did you want to proffer,
Eric.
Eric? That's right. All right, let's, we ready to bring him in anyway?
Yes.
All right, let's bring him in.
Mhm.
Good morning, sir. Welcome back.
And here we go. We're back.
You'll come on back down to the stand. I'll remind you, you're still under oath from yesterday. Before we bring the jury out and continue with, I guess we are going to go back to, you're going to reopen for direct regardless of what happens with this, is my understanding? You have some other stuff or just
No,
this?
I was gonna only reopen
Just
for
this?
direct if this was.
All right, well, we need to get some information from you, sir, outside the presence of the jury. So I'm going to allow Ms. Hershey to ask you some questions.
Mr. Lear, yesterday you discussed an incident in which you bought Joey Carey a bus ticket when he ran away from Virginia and came to Florida. Is that correct?
Correct.
And what was your understanding as far as what the purpose of him running away for, or why he was coming to Tampa?
He told me he was being abused by his mom and dad. And I asked him what happened. And he said that previously they had broken his arm. They had flushed his face in the toilet. They had made him sit on a heater. I mean, it was enough for me when I heard that much.
So you purchased the bus ticket for him and he comes from Virginia to Tampa.
Yes.
Where is Nicole at that time? Does she remain in Virginia?
Well, she didn't come with him. So,
Okay.
yeah.
What, if any, other instances of abuse are you aware of? First, let me ask you that you're aware of as it relates to Miriam Deans and her son Joseph.
When Tampa Bay Mall used to be there,
Well, let me stop you. I don't mean to. When he came back and when you got him the bus ticket and he arrived in Tampa, did you notice any injuries consistent with the abuse he had described to you?
no bruises or,
Like he didn't have a broken arm at that point?
no,
things that had
he said
happened before?
previously. yeah,
Okay.
yeah.
Tell me about any times where you witnessed or became aware of abuse by your sister on Joseph.
One time he called me from Tampa Bay Mall when he used to be there. I'm not sure. I think he was maybe 10 or 11. I'm not sure how he was, not driving age, so he was younger. And he told me to come get him. And I said, what's going on? And he said his mom drove a key into his forearm and left him at the mall. So I told him I'd be there to pick him up. And I
And
did.
did you then see an injury that corresponded with something consistent with what he had described to you?
Yeah, he had I don't know if it was a deep scrape or, it was just, there was blood there. It wasn't like requiring stitches or anything like that, but it was pretty scraped and It looked like somebody just
Keyed him?
keyed him, yeah.
Any other instances of abuse by Miriam on Joey that you're aware of or you know of?
Just what he disclosed, just what he disclosed over the phone to me when he was running away.
Okay.
Um,
And then
other
the
than
mall, anything else other than the mall and the phone running away?
Not that I recall.
Now, I want to ask you if at any point, whether when it happened, after it happened, at any point in Nicole's life, are you aware of whether Nicole knew about these instances? Did she know about the running away and why? Did she know about the mall incident and the key incident? If you know.
I'm not sure specifically. I know that one time we were discussing about things that had happened to Joey at the hands of his mother.
Who was discussing?
I was talking to my mother. Nicole was there on the lazy boy. And I think my son might have been there.
Hunter?
Yes,
So there was a period of time where your mother, Miriam Lear,
She was there.
and your
But
son
was she
Hunter and you
paying
were in
attention?
your mother's house.
yes.
And tell me what was being discussed about the abuse of Joey in front of Nicole.
Because she had arrived and she looked,
Who's she?
I'm sorry, Nicole arrived there and she just looked upset, or she looked upset. And I said, what's wrong? And she said, I can't. She just kept saying, I can't. So I guess she couldn't tell me what it was. Then because she had confided in me once before about her mom hitting her, I felt she couldn't trust me because I think it came back to bite her after I confronted my sister about it.
So Nicole had previously reported some form of abuse by her mom. She
Yes.
tells you about it and you went to Miriam about
I
it.
confronted my sister about it.
And Nicole didn't want to tell you the second time because I guess she felt you were going to go to her mom.
Yes.
So tell me what the discussion is at that time about the abuse of Joey or what was said about Joey in front of Nicole about anything Miriam may have done to Joey as a kid.
Well, I said, you're aware that you can tell me because the same things happened to Joey. And she said, I can't. She wouldn't tell me.
And when you she was physical or somehow
right.
physically abusive.
Yeah, because it was related to how my sister treated Joey, which resulted in him running away.
Judge, I don't have any other questions.
Do you have any questions?
Yes, Judge. Mr. Adair, that last statement you just said, you said to Nicole, you can tell me because the same thing happened. And then you indicated what you meant. You didn't actually say what happened at that time, did you?
Not to describe it, no.
Okay. And you said when you began this conversation that Ms. Hersey Folgera asked you when this was discussed in front of Nicole, and your response was, well, I'm not sure specifically, but I think it was at my grandma's house on one occasion. How old was Nicole?
She was driving, what's it called, age?
Okay, teenager, 16 over.
Oh, yes, at least,
And this was a conversation at your house.
at my mom's house.
And it was on one of these occasions when Nicole came to the house.
She showed up there.
And the specific acts of abuse were not discussed, just the same thing happened to Joey.
Yes,
And the reality is you don't even know if Nicole was actually talking about abuse when she said, I can't, do you?
correct.
You don't know if she was just talking about Miriam screaming at her or verbally yelling at her, do you?
No.
Okay. So to say the same thing happened, that's not indicating physical abuse or otherwise, correct?
Correct.
Okay, and I want to go back a moment. You said earlier that Joey told you about when he was abused by mom and dad, and you asked what happened, and your response was that previously they had done things to him.
Correct.
Okay, but I want to clarify because when you gave a deposition in this case, your specific statement was that my brother-in-law took his face, put it in the toilet, would make him sit on a heater, one of those heaters, and broke his arm one time too. So you previously said it was just your brother-in-law that had done that to Joey, correct?
If that's, I don't have my,
Can I approach him down there? All right, I'm going to show you what I'm reading. If you want to start up here at page 1, yeah, take your time. And for counsel, I apologize. I'm on page 24 of his deposition, lines 1 through
Now, either
8.
you remember your sister was part of that, or you don't. That's not just something that slips your mind, bro.
yes, that's correct.
Okay, so at that
It's not
time,
asked that he be asked to read the whole paragraph.
sure, and I'll read it. That's fine. It said, and according to Joey, he told me that the father and my sister were abusing him, that my brother-in-law took his face, put it in the toilet, would make him sit on a heater, one of those heaters, and broke his arm one time too.
Correct, but okay.
And then you went on to say, and that the same treatment was being applied to my sister by the husband.
Correct.
Okay. And the only reason I understand that you said that your sister was abusing him too, but those specific acts that you just mentioned here in court, you indicated those were by your brother-in-law.
In the deposition, I did say that, but I guess I wasn't asked specifically who did what, because when I spoke to Joey on the phone, and I had asked about my sister, because I'm like, why can't you stay with your mom? It was like, they're both doing it.
They're both doing it.
So I wasn't sure which one broke the arm. It was just a combination of everything that's been done to him under both their care.
When was this conversation with Joey?
When he, I think a day or two before he ran away.
When he was how old?
You're 16 or 15? I think it's 16.
16 or 15,
Yes.
which means that at that time, Nicole Nachtman would have been roughly 4 years old. She's 12 years
Yeah.
younger than him, correct?
So yeah, 3 or 4.
3 or 4 years old.
Yeah,
Yes?
correct.
Okay, and so Joey calls you on the phone about this bus ticket, and this is when he tells you, this is why I want to leave, because they are abusing me.
Yes, he tells me he's running away. I said, why? He answered those questions, told me specifics. It was pretty much they, but he said he was running away, and I asked him where. And he said, I'm just getting out of here. And I said, don't just go anywhere. Come to Florida. I'll get your ticket. You just get to the bus station.
And at that time, that was a conversation on the phone between you and Joey alone.
Correct.
Nicole was not a part of the conversation.
No.
She would have been 3 or 4 at the time.
Correct.
And Joey never indicated to you that Nicole witnessed it, did he?
No.
Nothing further.
Anything else from the defense?
No, good.
All right, so I'm gonna ask you to step outside while I finalize the legal argument with the attorneys.
Oh my goodness. It's so aggressive. Both those ladies are aggressive. Well, we are gonna stop this one and we are gonna put the doctor all on the next one, because that's what makes sense to me. So stay tuned, and they're going to bring in the brother on rebuttal to again tell his story about why he ran away. And brother seems to be on mom's side. Not that he's not on sister's side, I guess, at some point. I don't know. I guess he doesn't believe in... I don't know. I got the vibe him and the family have some... they aren't really on speaking terms. So it feels like the family is working with the defense to try to get on their narrative, and then the brother is trying to work with the state on their narrative, which is kind of an odd situation. I don't know. So, but the doctors should be an interesting one. So, you'll have to come back and watch the next one. That's what you should do. Talking, that's the problem here. All right. Well, I will see you on the next one. Remember, like, comment, subscribe. Let me know what you think in the comments. And if you have any suggestions on what we should do next, because this one is almost over. Because we are on day 6, and I think there is only doctors' testimonies left, and then closing arguments, and then that's it. So, if you have any other suggestions or thoughts on something that you want my opinion on, shoot me your suggestions, and I will gladly look into them. All right. Well, join me again for the next episode of Rush to Judgment Reacts with this Nicole Nachtman trial. Okay, I will see you on the next one. Deuces.